The House Judiciary Committee this Thursday, May 15th, and we're going to look at the latest version, draft number 3.1 of S109, the amendment to S109, and over to Eric. Thank you for being here, Eric.
Yes, thank you, and good morning, everybody.
Good morning.
Eric Fitzpatrick with the Office of Legislative Counsel. Nice to see everyone this morning. Here, as the chair mentioned, to walk the committee through the latest amendment to S109, which is the miscellaneous judiciary bill. Since the last time I was here, the bill has gone through and been voted out of both House Ways and Means and House Appropriations. A couple of the amendments you'll see in here were proposed by the House Appropriations Committee. So they were, rather than having them make their own amendment, they decided it was more efficient just to fold their suggestions, and Representative Ravenson was at that committee meeting as well and agreed to that idea to go ahead and just fold it all together to be more efficient. I'll point those out as we go along, which ones those are. There's also a couple of other changes that I'll point out where they came from. For example, you may recall the back and forth for DCF. That's their new language edited by us is reflected in there as well. So having said that, I can do a quick walkthrough of the instances, just kind of to refresh everybody's recollection, if that makes sense.
Sure.
All right. So the first instance of amendment, page 1, strikes the public inebriates sections. Remember that? Those were the sections that were in the bill that passed out of committee, but they were also in S36, which is now on the governor's desk. So it was sent over Friday, I think. So rather than have it two places, without being inconsistent, keep it in S36, which is where, as I say, with the governor now. That's the first instance. Second instance of amendment, this is one of the ones that was requested by the House Appropriations Committee. And this was the idea. This is the Firearm Surrender Order Compliance Working Group. Remember, this is the working group that is going to look at all these different places in Vermont law where firearms might be surrendered and try and come up with some consistent procedures. So it's not adding any authority or any instances where firearms can be surrendered, just trying to see if some across the board consistency can be achieved and what procedures are taken to store the firearms, keep them safe, return them properly when they're supposed to go back to the owner, that kind of thing. So House Appropriations suggested adding that the new change here is line 13, subdivision 11. They were saying that Fish and Wildlife might have a say in this because sometimes when people are arrested for deerjacking, for example, or ticketed, that sort of situation, it's common practice for Fish and Wildlife to seize the firearm. So they thought it might be relevant for them to be involved, and they are. Just you can't really tell by looking at this, but you may recall that the working group had members of the working group and people who the working group consults. Right, two different things. So this is not adding a member to the working group; it's adding them as a consultee. So working group.
All right. Yeah, I did. Yeah, I did too.
Yeah, sorry.
No, that's fine.
There's law enforcement in the working group, right?
Yeah.
Yes, exactly. Yeah. Several of them. Yeah.
I would rather see him as be consulted.
Yeah, because we have two entities that are law enforcement.
We had eliminated some members because they were duplicate.
Yeah, that's right. Yeah, exactly. So that's that one. The next one is also a suggestion from House Appropriations, and that was a technical one. It was a nice catch. Also to do with the Firearm Surrender Order Compliance Working Group. There were a couple of instances where I should say, incorrectly used the term task force. Oh, we were talking about that.
Hi.
What's a task force? What's a working group? So within the working group, it kept working group, and then two places for some reason it said task force.
What's the difference?
I don't know that there is one.
I know
Substantively.
we've had this conversation.
Yeah, right,
before.
exactly.
I even looked it up once, and there's no difference
Yeah.
between a working group, a task force, and a study committee.
Right.
They're all pretty much the same thing.
So Zone said there were differences. Remember, he went into that. Yeah, he went into it. He had an opinion about it.
Okay.
And then I asked Justice Ryber if he agreed with if he was going to overrule. Judge, I remember.
And the chair of appropriations had asked Pledge Council to vote on that this summer, or some, yeah.
Yeah, to raise the issue with our office, the chair of appropriations, as Representative Rachelson was saying, asked us because she asked me that same question. I said, I don't think there's any difference. I guess I should have listened to what Judge Tony said. Yes, exactly. Would it be a study committee studying the task force, working group?
Like the community.
Study committee
Exactly.
tasked with.
All right, right.
The work for the, generally, I think has a broader charge, right? The task force is like a specific, a more narrow,
Oh, that's a good point, right? Maybe that could be it, right?
if I remember correctly.
Well, in that case, this should be a task force.
Sure.
Too late.
Too soon.
Either way, it should be consistent within the same section. So
Yes.
whatever term you use, be consistent. So that's what they noticed in the House of Probes. So what this does is it changes the term task force to working group like it was throughout the rest of that section in 2 instances.
Trevor.
So that's what that's that one. Next one, fourth, starts at the bottom of page 1, but really the language is over on page 2. And this is the new language from DCF regarding, you remember the issue being when it is that a parent's history of child support payments can be taken into account for purposes of TPR proceeding. And remember, because there's another section that's not amended here that's in the bill that was the part where you were reinstating language that was repealed last year that makes clear that the past history of child support can be taken into account for these proceedings that are more between the parents about, you know, how parental rights and adoption should go in terms of not state involvement between the parents. And in those cases, maybe one parent's payment might be relevant to where the custody should end up. But in these situations where it's not between the parents, but a state DCF, state petition to terminate parental rights, in that case, they wanted to be clear that, well, child support history is not a relevant factor that they consider. So they've tried to narrow it much more than it was in the previous version that we saw. So it says specifically that the Family Services Division shall not consider payment of child support to the Family Service Division to offset the cost of foster care. So in other words, their past payments to offset the cost of foster care that they had incurred as a factor in a petition to terminate parental rights. It's the same language in both sections there.
All them from having to pay any counsel?
No, it doesn't absolve them of the requirement. It's just saying that whatever their history was, whether they paid or not, when DCF decides whether they're going to terminate your rights, that's not something we're going to look at. It doesn't mean that you didn't have to pay or that you couldn't still be penalized for that.
Actually, Heather, I thought on Friday, because I was asking that, I was like, aren't there times that somebody not paying their child support might factor into a neglect determination? And she said that they still could use it for that, but this was very specific for when a child was already in custody, that it not be factored in for paying for foster care.
Right.
So I just want to make sure that is sound before I share that. I mean, I have notes from Friday, but that was my takeaway.
Yeah, and I think that's why they added the to offset the cost of foster care.
Yes.
So.
But it still can be a factor in determining abuse or neglect and terminating parental rights. I don't think it's often happens, but I think it might be an indication of somebody. And does that read that way to you, Eric?
Yeah, that's the way it reads.
Okay. Thank you.
So those two, 25A and 25B, the language is identical. I think the next few instances of amendment you saw in the last version, both the 5th and 6th, bottom of page 2, were requested by the House Corrections and Institutions Committee. And that was, the first one is just a grammatical change, dates plural to dates singular. And the 6th one, the Victim Notification System Task Force, is just adding an additional member. It's over on page 3, line 12. It adds the member appointed by the Commissioner of Corrections, who's familiar with the capability and technical operations of the VINE system. The VINE is a national victim notification system that DOC uses and victims can sign up for. And I guess they already have some people, someone in mind who has this technical familiarity who they were going to appoint to the task force. Seventh, page 3, this is a request from Representative Donahue to include the language that's over on page 4, lines 7 through 10. And that is just truing up the language in the report with the language that's in the charge. That's all that is. So that same language that you're looking at in subdivision D on page 4, line 7 to 10, that the working group has to consider not only whether or not those two different guardianship systems should be merged in one court, but also whether or not, even if you don't, maybe some statutory changes should be made to make the two systems more equitable. That piece has to be in the report as well as was in the initial chart. So that's all that is. The eighth instance of amendment starts on page 4. This is the, now each time at each one of these, I look carefully to see if it's a working group or a task force. This one, child and parent legal representation, is a task force. This is the one that is chaired by the Chief Justice. So you'll see it over on page 5, lines 5 to 6, clarifies that it's the Chief Justice or the Chief's appointee who's the chair. Also, although it's not here, and that same page, lines 1 to 2, what's language that is not in this version, there is the words relief from abuse petitions. Remember, in the previous version, this task force was going to be looked at legal representation for children and families who are involved in various judicial proceedings. Change proceedings, substantiations of an abuse and neglect are the ones that are there. And also in that list was relief from abuse petitions. But after some conversation, I think, with the Center for Crime Victim Services and other folks, I think the Voices for Vermont's Children, Parent Representation Center were also in here testifying on that. And I think that's where the committee landed, to take that out. 2 new members are added to this task force. Lines 15 and 16, the Attorney General and the Executive Director of State's Attorneys and Sheriffs, 8 to 9 are added. And lastly, it's just the same, another instance of relief from abuse orders being struck, and that is also struck in subsection E of the report on page 6. For the list of items that have to be in the report used to also include the relief from abuse petition for children or has legal representation connected to those proceedings. Not there anymore.
I think on line 17, page 5, should it say the executive director of the Department of State's Attorneys and Sheriffs?
I had that originally, and the editors took that out and said that's actually not the way it reads. And for example, it's sort of like you don't say anymore the Commissioner of the Department of Corrections. It's Commissioner of Corrections.
Okay.
So that's the way the convention is now.
I'll be just.
Yes.
We didn't read
The more
that.
you know.
Good to me.
Yep.
All right. Are people good for me to ask for a motion to find this favorable? I will ask for a motion to find draft number 3.1, that's 109, the amendment, favorable. For a second?
Second.
Are you good? Are you ready to vote, or should I withdraw that?
You have nobody in the room.
No, we have 6 and we have 2 people there, so we'll have 8 people, and I will
It's a straw.
talk to Tom and Zach to see what their votes are. If they want to vote. Are you good? I know. Well, I can give you time.
What are you gonna do in the meantime?
I'm gonna move on to another thing. I'm gonna do a
Okay.
drive-by.
If you don't mind, just.
Yeah, that's fine. So I would.
Just trying to catch up.
Motion.
Just trying to catch up on a couple.
I withdraw the motion.
We'll try to, I do want to try to have the vote before.
No, that's fine. I just gotta catch up.
Yeah, no, it's fine.
Just, I was
Um,
looking at the wrong thing here. It's like, if everybody wants to know on camera what happened,
no, It's, hey,
Love you.
not gonna-
Does this have to go back to other committees?
I don't think so.
Appropriations? doesn't-
No, sure, there's no.
Okay.
So,
I just, I didn't.
I mean, check Betsy after we voted out, just to
Okay,
make sure.
all right.
I mean, it doesn't have anything that's,
I just didn't know what the,
right, so I just double check with them. All right, so we'll move on to a drive-by, flyby pit stop about a bill, H-145 that is in government operations, and they wanted us to look at one bit of this.
okay.
And so we have Eric and also Tucker Anderson to help us understand this and what they kind of want us to weigh in.
So I'm gonna defer to Tucker initially, just because he has the background on much more so than I do. I've looked at this narrow part of the issue that I can help out with after you hear from Tucker, but I think might be more helpful for the committee to hear from him first. So, thank you.
Welcome to our committee, Tucker. We haven't seen you this biennium, I don't think.
Yeah,
Thank you so much for having me. For the record, Tucker Anderson, Legislative Council, and it's good to be back. It's good to be back.
Insurance and bar.
It's just a blurred memory from the last time I was in here, which was liquor liability insurance.
that needs it to be.
A very nuanced and complex discussion with many angles and many reasons to forget all of the time in between my last comments. So
And it was wonderfully drafted, multiple amendments on that bill. So thank you.
thank you for saying that.
You sound relieved.
I'm gonna put it in my employee file.
I noted it as well.
If the committee would like, I can share my screen. Having not been here in a little while, I don't know what the typical,
Why don't you share the screen? Because I don't know that Representative Christie and Representative Malay necessarily have the document in front of them.
Okay.
So why don't you do that?
while I'm allowing the technology to boot up, I'll give you some descriptive background here, just a minute on where this is coming from. Currently, under both Title 13 and the open meeting law, there's a tension for public bodies of the state and particularly local government in the application of, we'll call it, disturbances during open meetings. Instances when members of the public are disrupting the meeting so that the meeting can't happen, where their conduct during the public participation phase of an open meeting causes the meeting to stop. And when a threshold is crossed where there might be a criminal act that has been committed during the meeting. And that would be in particular disorderly conduct. Representative Harrison introduced H-145, which set up three things. First, an expression of legislative intent, which lays out some factors from a Supreme Court of Vermont case called State v. Colby. Then gives public bodies the express authority to adopt rules governing public participation in open meetings and to dispense of what could be hours of discussion about the constitutional parameters around open meetings. Open meetings are purely a creature of statute. There's no constitutional requirement that meetings be open. It is something the General Assembly has created, and you control, for example, public participation in those meetings. So what Representative Harrison's bill did was allow each public body to adopt rules governing public participation in the meeting, including the ability to exclude persons who violate the rules of conduct for participation in the meeting. And then the final component of Representative Harrison's bill was to amend 13 VSA section 1026, which is the state's disorderly conduct statute, to add a new basis specifically that an individual could be cited for disorderly conduct when their actions cause the substantial impairment of the effective conduct of the meeting of a public body. think I can actually share my screen now.
So can I ask a question about how you refer to that? Is it a new basis or is it memorializing what already is law?
The latter. It does add
That's
a
big
new
difference for
Yes.
adding disorderly conduct offenses.
jumping.
Or clarifying versus adding something new, then we don't have to take possession of this. So,
Representative Harrison's bill did add a new subdivision to subsection A, which lists out the bases for a citation for disorderly conduct. And you have the language behind me. But every word of this in the first clause substantially impairs the effective conduct of a meeting is taken from the Supreme Court of Vermont interpretation of subdivision 4, which is in current law, which covers actions that disturb any lawful assembly or meeting of persons. There were two, I'll call them subsequent, although I believe they were separated by 40 years, Supreme Court of Vermont decisions. One was State v. Mancini, which interpreted a prior version of this statute and said that these sort of disturbances are evaluated on a case-by-case basis and are tied to the context of whatever the assembly or the meeting is that is being disturbed by the individual's conduct. And then State v. Colby, which really took a close look at this subdivision 4 in the context of individuals who had stood up during an address from the Director of National Intelligence at the St. Johnsbury Academy commencement. And they stood up, they shouted a few things, they started to heckle, and then they called for the assembly to follow them out of the auditorium and leave in protest. No one did, but those two individuals were escorted off site. They were cited for disorderly conduct. Fast forward through what I'm assuming is years, they appealed to the Supreme Court of Vermont to get a final determination of whether or not their conduct met the threshold requirements for citation under the disorderly conduct statute. The Supreme Court of Vermont, and I'm not very agile at navigating between sharing tabs here, so my apologies. In their decision, stated that what needs to be evaluated is whether the individual's conduct and not the content of their expression substantially impaired the effective conduct of a meeting, which is the language that is in H 145. This is repeated over and over again as how the court analyzes subdivision 4 as it is currently written.
So I'm just trying to think about, there are times that what I find is substantially impairing something might not be what Angela finds. Like it feels subjective, like I can tune so much stuff out that I'm just, yeah, okay, you've already got an answer for me, which is
You'll
awesome.
make an excellent Supreme Court justice because that's exactly where the Supreme Court went after establishing that, standard for substantial impairment. They gave two examples. The first is when conduct that causes a lawful meeting to terminate prematurely and not a pause, which is what happened in the case of the St. Johnsbury commencement. They said that the speech was 8 minutes long and was paused for no longer than 30 seconds. Not substantial enough. But if the meeting had been caused to terminate, they had closed down the ceremony because the disruption was so significant that it would have met this standard.
So the person who determines if the meeting is going to be closed, I might argue that if you like the disturbance that's being presented, you might tolerate it and not find it annoying. And if it's counter to one's personal or, whatever, you might end the meeting. Like somebody Like, that also seems,
So it depends on what type of body we're talking about. Some will operate under Masons, like you all do, and some will operate under Robert's Rules of Orders. But under both, it is the chair of whatever the body is that makes the determination to call a meeting and to close or adjourn a meeting. However, Representative Harrison's bill did contemplate some of the concerns that you're raising. And currently, under the open meeting law, the rules governing public participation are adopted by the chairperson only. Representative Harrison's bill amended that portion of the open meeting law to state that for purposes of rules that would govern public participation and the exclusion of members of the public based on their conduct, that it would have to be rules adopted by the body as a whole in order to balance the interests and provide some sort of more objective criteria for that public body to exclude the individual and potentially, depending on the scope and impact of their conduct, lead to this criminal citation down the line. And something important to note here is that even if the meeting were to stop for a period of time, the individual always kind of has an escape clause because they could disturb the meeting and cause it to stop for a period of time. But when they are told to stop that particular conduct or act, and they do, and they leave the meeting when asked to leave the meeting, it would not lead to a citation. And that gets to the second example here that the Supreme Court of Vermont gave us. And that is that there is substantial impairment where the defendant makes numerous and sustained efforts to disrupt a meeting after being asked to desist. So you have some notice, stop attempting to disrupt the meeting. The individual says, A-OK, I'm done with my shouts, and the public body can move on. You don't have a citation.
So Barbara, I mean, would it help if those examples were specifically moved from, because they are in the legislative intent, but should they move under the subdivision 6 for the clarification that I mean, that's what I would think.
I think that sounds good.
Yes.
I wouldn't have thought of that, but that sounds good.
Yeah.
Are you, Tucker, are you done with your presentation? I don't want to interrupt.
I'm panicking because DM is about to save over the entire amendment.
Okay.
Yes.
So if I understand correctly, 6, the language in 6 is the Supreme Court's interpretation of 4 from State v. Colby. Why not just either totally replace 4 with 6 or mush them together into a modified 4 that just captures the steps of substantially impaired language?
So I will say that that was a policy choice that was made to take a half step that is specific to meetings of public bodies. Subdivision 4 is applicable to any assembly or meeting of persons.
Yeah.
And the decision here was to add a new subdivision that related specifically to meetings of public bodies, using the highest standard that we have from the Supreme Court in this context, and acknowledging that the way that the open meeting law is constructed, you have a limited public forum that is constructed for portion of the meeting. So without touching the disorderly conduct, provisions in subdivision 4 as a whole, this just called out meetings of a public body.
So it's narrower than it, but did the Supreme Court case involve the public body as opposed to?
No, that's why I'm wondering, they applied that stricter standard to just a meeting of people. So why not just, if that case is still going to hold, and so if someone were to bring a disorderly conduct against somebody from an open public, from a meeting of peoples, they're probably going to still be applying that standard from Colby.
It's an excellent question. And you have an excellent attorney in Eric Fitzpatrick who anticipated that these questions might come up. And so Eric and I used the General Assembly's technology to connect our brains yesterday evening. Late yesterday evening. And by this morning had prepared the following. for purposes of government
You
operations.
said you were done.
I was done with that portion,
Ah.
Yes. but you started working on part two. First, an expression of legislative intent. That states that section 5, which amends the disorderly conduct statute, is intended to incorporate the constitutional requirements that were articulated in State v. Colton. So just telling the world, and especially the courts, what we're attempting to do here is to amend that subdivision 4, clarify that we are incorporating the standards given to us by the courts in interpreting the subdivision. And instead of adding a separate basis, it instead adds a subsection C, which defines a few terms. It defines the language used in subdivision 4 here in this second clause, disturbs any lawful meeting, means conduct that substantially impairs the effective conduct of an assembly or meeting, including conduct that, so you have that standard first, and then calling out in subdivisions A and B, the two examples that the Supreme Court of Vermont gave us of when you have this sort of action. Conduct that causes an assembly or meeting to terminate prematurely, or that consists of numerous and sustained efforts to disrupt an assembly or meeting after being asked to desist. Now, because this is doing it for all assemblies, it doesn't get to one of the sort of soft concerns that has come up here, which is that particularly at the municipal level, there was a lot of uncertainty as to whether this sort of charge could even be applied in the context of a meeting of a public body, because there were heightened concerns around, for example, First Amendment rights, both the right to speech, but also the right of any member of the public to assemble at these meetings. So that's why the term public body was used in Representative Harrison's bill. It was to call out specifically open meetings governed by the open meeting law. Yes, this provision would still apply. So we define meeting not in a narrow way, but just to state that, yes, it includes meetings of a public body as those terms are defined in the open meeting law.
First of all, I'm very impressed with your patience. Like that I love how you just did that. It's very dramatic. Presentation.
Deal.
My question is, referring back to something you said about how it is ultimately the chair's decision to end a meeting or, or continue, or other, the chair makes all kinds of decisions. And you mentioned that the body together collectively, and I don't know if you said could, it says, I'm saying may in page 3, line 7, may adopt rules governing the conduct and participation of the public, which may include rules that prohibit the disruption of a meeting. So I'm wondering if the thinking there is that the public body they might have these rules, which would certainly help a chair make a decision, and I would think would help in any legal challenge to that decision. But it's not directing public bodies to develop those rules.
Correct.
So that's a policy decision. I'm wondering if you can shed any light on that choice.
Currently, the authority to adopt rules governing public participation is discretionary as well. And it is certainly something that has caused issues, especially for the local public bodies that are trying to navigate disruptive behavior during public participation. And I can't speak to why the policy choice was made to keep it discretionary instead of mandating that these rules be adopted. Certainly, one of the things that I walked government operations through with the overall intent of Representative Harrison's bill was to establish intent, notice, especially notice to the public about the potential for these rules to be adopted. And then if the legislative body, instead of the chairperson, is adopting the rules, that means it has to be at an open meeting that those rules are being adopted and voted on by the public body. So you have another step of notice. And the hope behind the intent is that these are going to, some of them, be bright line standards that the public is aware of. So examples that were given in government operations were time limits on how long you're allowed to speak during the public portion. Bright line standards for the type of conduct and speech that is acceptable within the meeting. So for example, constraints on talking about items that are on the agenda. Right? That's what the public portion is supposed to be constrained to under the language of the open meeting law. But if you don't have rules governing that, it's difficult to then enforce during the meeting.
Yeah, and I'm just thinking about the concern that you raised, Barbara, about like a chair having that much discretion. I mean,
That part's kind of not in our jurisdiction, though. We're-
I guess, yeah, that was my question, I guess, if it came up. If
It'd be good to be comfortable with it. Go ahead, Barbara.
So a couple things. One is this body has to come up with these rules before, like, if all of a sudden this meeting were disrupted and we didn't have rules in place, what's the default is it's up to the chair, right?
It depends on what we're talking about, but if we're talking about ending the meeting.
Yeah.
Yes.
Okay. So if a chair decides that, you know what, we're not going to make rules because I like having all the power, there's nothing in this bill that would require a vote to see if the body wants to adopt rules. It's not a mandatory action. So no action could still create the concern that I'm concerned about.
But I would note one thing about the position of a chair on a public body. It depends on the statutory structure around the public body that we're talking about, because there are, for example, chairs that are called out by ex officio by their position. But in general, chairs are elected by the public body at their first meeting, particularly at the local level. You have your annual meeting, the public body reconvenes, and immediately their first act is to elect their chair. So the body has control over the person who ultimately will be making this decision. So there is still some sort of representative and democratic value incorporated into picking the person who gets to make the rules.
And narrowing certain rules of narrowing, if it's like, here's the public comment portion, but on the, like, if it's not on the public agenda, it seems like we are greatly limiting free speech. If somebody's like, there's a huge issue that keeps not getting on the agenda. So I guess I realize that's sort of not part of this bill, but you could see somebody getting disruptive if they feel like there's not an opportunity to speak on something. Right? Like,
But recall that all we're doing is looking at
Yes.
clarification
Yes,
of what, I mean, this is current law. And I think the
Okay.
idea from what I understood, this is from Jim Harrison, that the reason for this is that law enforcement were not clear from statutory language what they could do in these situations, nor were these public bodies. So we're taking it from the Supreme Court and putting it in
Okay.
place so that they
are clear.
are clear, is my understanding. Is that?
Yes.
And is signage dealt with? Because I know that's an issue in this body, right? Like if somebody's holding a sign up, I just wondered if
That starts to foray into some First Amendment considerations. And one of the things that the court talked about is that there's quite a bit of analysis that has to go into the tension between First Amendment rights that are implicated at an open meeting. You do have individuals who want to speak, but you also have citizens who are there to attend and see that the conduct of the business of the public body proceeds.
right.
And they are there to peacefully assemble. So it is navigating the tension between First Amendment rights that becomes difficult. So the hope is that you have rules navigating the orderly conduct of the business of that meeting, which is a meeting of the public body. It's not a meeting of the public. We can get into some very interesting conversations about what happens in an annual meeting in this context, which is a meeting of the voters that is kept in order by a moderator, but there's no public body holding the meeting.
Right. Okay.
And then Eric?
We're getting ahead. As a practitioner, I appreciate exactly what's there very much so because I believe that things should be orderly in a meeting. But the concern I have, looking in, being called to go to something like this when something's happening, is to one side might see things differently than the other based upon what they're meeting about. And having a chair decide, well, we need to arrest this person because he's being disorderly, but on the next meeting, letting it go, or the previous one. It's not up to that person to make that decision. I should be able, as a practitioner, be able to go there and say, yeah, he's breaking the law.
Colby, in its analysis and discussion, did point out that when this is applied, it should not be based on the content of the speech, but on the actual impact of the individual's conduct. So you might have issues depending on who the chair is, but ultimately the fixed legal rights of both the citizen and the public body, there's going to be objective disruption.
Possible that a chair or the body, whatever, could let something slide in one meeting and then not enforce it, or then enforce it in the next one. I totally can see that happening.
Me too.
Well, this is sketchy with me. But go ahead.
Thank you, Representative. And yeah, just to add a little bit here, I think you're right that it is possible, but that doesn't change anything from the existing law. All it is attempts to help, but I think you're right. It's not gonna solve that dilemma completely. It's gonna hopefully assist law enforcement by providing some concrete examples when it is you can ticket somebody. And I would add also in response to what Representative Rachel's concern was, and this is another sentence from the opinion. When talking about the standard here, right, that this language verbatim from the opinion, conduct that substantially impairs the effective conduct of an assembly or meeting, court says the standard is an objective one. The fact finder may not consider the subjective intent of the content of a defendant's expressive conduct at those assemblies, but must instead evaluate it in terms of timing, duration, or intensity. So yes, it is possible that you might have some arbitrary and capricious chair, to coin a legal term, or I didn't coin it, to use a legal term, that might push the boundaries of what they could do in terms of ending a meeting early or something like that. But all other objective factors that will go into that, like let's say it was a very short statement made by the speaker, it really wasn't very intrusive. Nobody else on the body found it intrusive. It wasn't loud. It wasn't of great duration or intensity. All those factors, I think, would go into saying, you know what, that's not a criminal violation. Is it provide, 100% clarity? I don't think that's possible given the nature of the disturbing peace statute, but hopefully it helps.
And there will be two different consequences, and we'll say that the criminal consequence is the heightened standard. But below that, you might just have the chair asking that individual to stop, slightly above that, asking them to leave because of their continued conduct, right? And the Supreme Court of the United States has not fully fleshed out analysis of heckling, but we do have a ton of great decisions, especially from the Ninth Circuit, say that just a simple heckle is constitutionally protected speech. And that particularly our public bodies should anticipate that they are meeting a confrontational audience every time they assemble to conduct the government's business. Heckling is in the roots of our democracy.
Yeah, I could follow up on that. In the Colby case, it listed some things that aren't criminal. As Tucker said, heckling, interrupting, harsh questioning, and booing. Yeah, so those are booing, yes.
Can't yay.
I didn't mention yay, that's an interesting question. That would seem to be content based, but you could boo in that.
It didn't call out hissing either, so.
That's right.
Bring my cat.
I think it's great. And having run select board meetings for a number of years, I think the clarity that it's providing is going to be helpful for at least some. It would have been helpful for some meetings I had. I think my only question is, are members of the public body, so in my instance, like a select board member, could they be charged with disorderly conduct, based on their conduct in a meeting.
Well, let's take a look at the language. I believe this says that a person, so not narrowed to the public,
Yeah,
disturbs any lawful meeting or lawful assembly or meeting of persons. I don't see language here, and I would defer to Eric that would exclude officers of a board that perform similar acts that meet this threshold.
Yeah, I agree.
I don't, I just wanted to clarify. Yeah, okay. Could you argue that, someone, one of the members of a board missing many board meetings could substantially impair the effectiveness of the conduct of the assembly?
So my immediate response, this is a very interesting, novel, hypothetical question, but I will point out that the language that is used here points to an assembly or a. So it is about conduct at that particular gathering. And one thing that the Government Operations Committee briefly considered and then navigated away from is evaluating concurrent, chronic, or consecutive disturbances that impair the conduct of a series of meetings. That has been set aside.
So the only thing I have on this is just that the conduct doesn't seem, at least the way I read it, the conduct doesn't seem to be like necessarily connected to being at the meeting itself. So for example, if in protest, we 5-member board, 3 members of the board choose not to show up to the meeting because they don't like what's on the agenda, could they then be charged?
I think that's objective, not, doesn't rise to the level.
Okay,
Action.
okay,
Pretty clear.
that they're, okay,
Just a failure to attend by members of that. And also, I don't know the answer to this, I'm just throwing it out there because you raised the question earlier. I wonder if, yes, it looks like on the terms of the statute that a member of the body could charge, but I wonder if there's some kind of immunity or privilege that would apply. Analogous to the legislative immunity for debating things, that may or may not be an issue. That just popped into my mind.
Context-specific analysis for purposes of the statute that Mancini originally adopted and that was repeated in Colby also says that you're supposed to evaluate the application of disorderly conduct under subdivision 4 within a specific context. And perhaps that member of the public body is attempting to represent the interests of those that have elected or appointed that member of the public body by not attending meetings.
yeah.
Thank you.
Oh, wait a minute.
I'm curious, does a chair have, lawful authority to disturb an assembly or meeting of persons?
Oh, sorry.
That,
No, I love these.
that is a fantastic question that I don't know the answer to.
Can you just repeat it?
So it says, yes, without, 4, which is just above here, without lawful authority disturbs
Clause,
any
yeah.
lawful assembly or meeting of persons. And I'm thinking, if a chair prematurely ends a meeting, like against the wishes of other people at the meeting, and if they've said, please don't end the meeting, and the chair says, I'm ending the meeting, so the chair's been asked to stop and doesn't stop.
Oh, just.
If the person with power, I'm trying to make sure they're not immune. Unless everyone on the body is immune, which we haven't.
That's going to depend on the rules of order that apply in the given context and whether, for example, the body has authority to overrule a decision of the chairperson based on a 2/3, 3/4, whatever majority vote to do something else. It would be rare, but I think it's an interesting question. What is covered by the without lawful authority? My assumption in reading this a few times and not seeing any court analysis of that particular clause was that it was describing instances when you might have multiple assemblies where there are, for example, permits for protests in multiple locations, right? And they might be causing disturbances, but they have lawful authority to be present in that place at that time, and their conduct therefore is excluded because they have authority by law to scream, march, wave signs, whatever the case may be.
So getting back to what we're here for.
It's so interesting
It
now.
is very interesting,
It's really
but we need to move on to the right to farm.
Oh,
So we're just here to take a look at this, see if there's any huge red flags or if, because this is different language, for us to suggest, and they can do whatever they want with our suggestion in GovOps, that it would be better if they added this clarifying language to what they have, where it just says substantially impairs the effective conduct of the meeting of a public body. I think we should suggest that they add this language. I think it makes it better. And are anybody opposed to that suggestion going by way of Tucker up to GovOps?
I would add to the suggestion, but it might be outside of our, I think it would be a lot easier for public bodies. And again, also like having chaired a public body and,
That you disturb all the time.
possibly or not, we don't know. Of course, it does make sense for public bodies to adopt rules governing the conduct and participation of the public, but not all public bodies do that. And I wish strongly that I don't know if it's even right for the legislature to mandate that they create such rules, but it would certainly help clarify a lot of things for a lot of people if those rules existed, if they had to exist. So I think it would
So-
strengthen
so-
the change that we are suggesting if they considered perhaps requiring adoption of rules.
Yes, that's
That's
true.
all.
That's true. You can drop that as a secondary suggestion, but not a hard suggestion because
I
that's kind of out of
second
our
that
realm.
secondary.
Oh, I got a second.
Um,
one thing that comes to mind, thinking about through this, probably, but one in particular is if you have different bodies, different groups of people doing different things, you're gonna have different sets of rules that are gonna eventually, it's not gonna be even Steven in one body to the next body if someone's gonna get prosecuted for that too. And yeah, I know, but and then you think about the civil First Amendment potential violations that could come down to that. As a law enforcement officer, I would just like to see what behavior is not allowed here. And I can say, that's not allowed. Instead, it seems to be very subjective.
And it makes your job hard.
Yes, very much so.
I mean, is that something that could be passed on to GovOps as well? I mean, I assume that's already given the huge list of witnesses they've looked at.
I will pass that on. The one thing that I would note is that you do have some very objective criteria in the second prong, which is the numerous attempts to disrupt the meeting, consistent, numerous. Don't have language up in front of me anymore, but that a law enforcement officer would have some sort of objective criteria to go on. The chair asked the individual to desist 3 times. 3 times the individual resisted, went over their time, disrupted the meeting. Public participation was called to an end because they could not get the individual to cede or yield the floor during the meeting.
I'm just concerned because it can, we talk about, we keep saying like a ticket or a citation or something, but this stuff can escalate a lot faster into much deeper territory.
Yes. And if you would like to see some testimony about the way things can go wrong, there were a few towns that came in this week to present testimony. They also sent YouTube links to recordings of their meetings, and in particular, the town of Fairhaven spent quite a long time describing issues that they have had.
Very, very, very brief. It looks like the language we would be moving forward with would not capture like Zoom bombing, which I don't know if there was testimony about that. but that probably would not rise to the level substantially. Is that what, like, sort of capturing what they're trying to capture as far as conduct that's disorderly?
It should be applicable to meeting or an assembly without context. The one caveat that I would throw out is that when I was researching what other states have done, some states have expressly adopted definitions for meetings and assemblies in this context to make sure that they cover virtual meetings of bodies. I want to say it's in M state, Michigan was the last one that I was looking at. I can see if there have been any decisions on that, but it is definitely an area that the committee was reticent to wade into. Most of what they considered was what happens with the meeting recording when there's pornography displayed during the Zoom bombing.
Yeah.
So,
Yeah, okay, thank you.
We had a very narrow question for us, which we answered.
Oh,
And we. Yeah, go ahead. So, yeah, go ahead. Yeah, kind of question.
It's about maybe the number of times, right?
Right, so that really quickly, that piece that goes back to GovOps, or like the enforcement part of it, or whatever that is. Why is that not more of our preview to deal with instead of GovOps? That's judiciary stuff.
Yeah, and so that's why it's here in a drive-by, and this is our suggestion, and I anticipate very much that they're going to take our suggestion, as opposed, the other opportunity, if we see that they don't, we can bring an amendment ourselves, but I don't think that's going to be necessary. So we've looked at the issue, it was fairly narrow, it's a clarification of existing law, taking what's in the Supreme Court to help clarify that. And so that's going to be our suggestion. And if they don't do it, we can come back to it.
And that's how you're understanding that, Tucker? How that's gonna happen with GovOps? Or you can't answer that?
I can't speak for what they will do, but I
How you understand it?
anticipate that your recommendations will be taken into consideration in Measure 15.
So I think that, yeah.
All right, okay, I'm good, thank you.
I mean, if we said, no, this is terrible and horrible, then they would kind of have to listen to us as well. And if we said, well, we have to take possession of this, but it's really mostly GovOps. So that's kind of why we just weighed in. Yeah.
Just want to make sure that part's taken care of.
Yep. No, I think it will be.
All right, thank you.
And we'll watch it to make sure it is. Thank you. Thank you very much.
Well, thank you so much for having me.
That was fun.
Let's go to.
We'll see you next year.
Next one.
Yeah,
All right,
yeah, we'll do it.
and I did write that thing.
Okay,
So interesting.
I love that.
so,
Take it quick.
so I don't think we have Mike ready to do a walkthrough for us today. I think I've relinquished him to another, committee that needs him more than we do at this moment, to get something through Ways and Means. But we can have him back, but David's going to do his best to tell us what the deal is. So, Chair Durfee, if you could join us. So thank you for all your work on the S-45 bill, and we're eager to hear where you all have ended up, and we can bring in, we'll find Mike O'Grady at some point
Okay,
if we need further explanation of something.
that would probably, yeah, I mean, I think we probably will want to hear from Mike. Good morning, David Durfee. Nice to see you all. I'm here as chair of the House Ag Committee. And I want to just start by saying thank you for allowing us as much time as you have to review the bill. I just heard that Martin Chair Lalonde use the term drive-by in reference to the bill I think you were just talking about. And it was our understanding that we're not supposed to use that expression anymore. So we have been calling it a flyover, I think. But flyover sounds like something that happens fairly quickly. That's not what happened in this case, obviously. So we need a new term that describes how much
Before,
Yeah,
Hovering.
covering maybe, yeah.
Like an extended layover.
Learn.
This- Yeah, it had an extended layover with us, so I just wanted to start by acknowledging that. And also say that when Mike walks through the draft of this amendment with you, you'll see you'll recognize a lot of the language because it's language that either you put in or that came over from the Senate version of the bill. I think also wanted to point out that you have the bill. It's never left your committee. So this is described the way that the intro is worded. It sounds like, here's our committee recommendation to you. And I talked to Mike O'Grady about that, and he said, yeah, well, we can leave it for now. It does, this is just informal at the moment, but you're, welcome to take this information and do what you want with it. So I'll just describe the process we went through, and then talk a little bit about what I think is in the proposed amendment. We were asked to look at the bill that the Senate sent to you, and then to look at the last amendment that you had been looking at. So we were pretty aware of everything that had happened, and we were also looked at existing underlying statute to try and really understand what does the existing law say. We heard quite a lot of testimony from farmers and from groups representing farmers. So we regularly in our committee, we have the Farm Bureau comes in, which is open to all farmers and represents all kinds of farms in the state. We also typically hear from NOFA, the Organic Farming Association, which represents all kinds of organic farms. And then there are a couple other groups, Rural Vermont, which tends to have among its membership small farms and other people who have an interest in rural Vermont, and then the Dairy Farmers Alliance, which, as you would guess, is dairy farmers. And I tend to think of it as larger dairy farms. I don't know whether that's a fair characterization, but in any case, those are dairy farmers. Interestingly, the Farm Bureau and NOFA, so those two organizations, which probably have the largest membership between the two of them, they didn't testify as organizations. They weren't able to have here's our position as an organization, because their membership wasn't able to say, I think, conclusively, this is how we feel about the bill or about changes to existing statute. But they did have members of both of those organizations that they had come in. And we heard some diverse, I would say, reactions to the amendment that you've been working on and to any changes. On the one hand, I would say rural Vermont, which speaks for a small number of smaller farmers, said that this is not something that their members had been agitating for at all. It hadn't risen to the level of this is something we need to push for. And then I would say, on the other hand, the larger dairy farmers in particular talked about the need for something more in statute than we currently have. I think that we didn't hear, although we pressed for it, we didn't hear very many concrete examples of instances where a farmer had been threatened with a lawsuit or whether there was something that might be pending. I think we understand that in the last 25 years or so, there's been one lawsuit, and it was fairly recent, that there have been maybe other things happening that concern farmers. And I think what I took away from the testimony we heard was that the concern is very real, that particularly larger farmers who have more neighbors and maybe conducting an agricultural activity that's more likely to generate controversy. But those farmers in particular were worried that somebody might bring a suit and that would be disruptive. And of course, we're constantly being reminded of the challenges that farmers face, not just in Vermont, but everywhere. And that it's a tough way to make a living, that we're trying in Vermont to, at the same time, we're trying to do everything else with our limited amount of land, that we're also trying to grow more food and do more to feed ourselves in the state. So we've got those competing pressures, and for farmers, it makes it tough, even without having to worry about, is somebody going to sue me for what I do? So let me just unlock my device here again, and I'll say, so I'm going to shift now, and please interrupt if you have questions, but I think what I'll do is shift to what we've got in this amendment now that we've sent over.
Is that anything we want up on the screen?
I don't know that, David's able to get it on the screen.
Okay, no, that's fine.
Isn't he done?
Sure.
Just the thought.
Yeah, I'm just going to talk sort of generally to it first, and then I can go through it, or you could have Mike do that.
Yeah, I mean, for Alicia and Coach, they can access, it's been posted on our website, so they should have access to it.
Yeah.
So I think there are a couple of sort of important things to emphasize that we've done. One is to, in general, shift the burden of proof from the farmer to the neighbor. So if there were a suit, from the defendant to the plaintiff. The current law, the structure of the current law has this rebuttable presumption with a set of conditions. And we heard that in a legal sense that puts the burden on the farmer if somebody were to bring a suit, for the farmer specifically to defend themselves, to demonstrate that they're meeting all of the good agricultural practices is the existing statute. So we've removed those conditions. And in fact, we've removed the rebuttable presumption construct altogether. You all came up with a new definition of, I think it was you, maybe it was in the Senate, of generally accepted agricultural practices.
Yeah, that's from the Senate.
Yeah, okay, so that we've left that in. You don't remember doing that?
I think there were a couple of additions to it that I can't say that we came up with, but probably witnesses into like Brady.
Yes, okay.
I don't know that we know about CAFOs, and I think that was added after it came from the Senate.
Yes.
But not
CAFOs are in there.
our instigation so much.
Well, in any case, the version that you last looked at had a definition, and we, I think, kept that definition pretty much intact. And then there was also in the version, whether you did it or not, I can't remember, but adding a requirement for a farmer to be able to demonstrate that they're in good standing with the state. And specific here, I think in this context, meaning they would need to get a certificate from the agency showing that they're not currently in violation, basically. So they need to be able to demonstrate that.
To get that certificate, I assume there would be inspections.
I think that you wouldn't be required to have an inspection to get a certificate. There are inspections that happen, yeah. So I think you could get a certificate if you, as a farmer, said, I would like a certificate. And then the agency would say, can't give it to you because there's a thing going on right now that you know about that we're trying to deal with. But unless such a thing were going on, I think you would get the certificate. There's two, and now I'm going to talk about two things that I think are also pretty important that we changed, not from what you had done, but from existing statute. There's two conditions right now that have to be met. One is that basically the farm has to be there first. So if somebody comes in and purchases land and decides to start farming it right now, I think you're not eligible, you don't qualify for the protection, the nuisance protection. So this removes that and basically says new farms are going to be treated the same as an existing farm would. The second consideration is for changes of farming type.
Is there a definition of new farm? Is that like new land, new operation, or can somebody purchase a farm and then?
It's actually not defined here at all. The way that it's written says there's a nuisance protection if you're farming. And that's the end of the, yeah. And obviously there's 7 pages or whatever it is, so it's not quite that simple, but it doesn't say anything, doesn't speak to whether you are there or not before that waiver. And then if you change the type of farming you're doing, similarly, it doesn't speak to that. So you would be able to change from being a vegetable farmer to a dairy farmer, or more likely from being a dairy farmer to a beef farmer, something like that. And then that's really it. The bill the version that you had added a mediation. Sorry.
That's a really big switch to not go through anything you go from vegetables and go right into dairy or vice versa.
This would allow that. Yeah.
It would, it wouldn't.
It would affirmatively, or it doesn't speak to it, so it would allow it. And currently, existing statute says if you change the type of farming you're doing, you lose the protection. And I think that the version that you were last looking at also made that change. So it said it's here. Yeah. So we're supportive of that.
So as long as they're following
Okay.
the reps and such,
Yes.
whatever the reps are for the new type of farming, that's.
Yeah. Yeah.
And
So Ken, before we go, Ken, I'm sorry, do you still have more on that?
Well, no, I just know what's considered a farmer is really expanded in the last 10 years. Let's just say 10 years that seems like everybody can be a farmer if you not picking on real stuff, like you plant a couple dandelions or something and you're a farmer. It's like, it's not what I'm trying to accomplish for this protection of farmers, that's all.
So there is a definition of agricultural activities in the beginning of the bill, and it's not entirely like a gardener. If you have a garden in your backyard, you're not a farmer. You have to meet a certain either income threshold or a certain number of animals or a certain amount of acreage. It's pretty generous, I would say. The income threshold is pretty easy to meet, but it's not anybody and everybody. But more maybe to your point, yes, if you've got a vegetable farm, commercial farm or an actual farm, and you decided that you would prefer to be hog farming or dairy farming, it would be you wouldn't lose the nuisance protection.
I was just gonna add that assumes that you've gone through all of the other necessary steps to switch your farming operation and that everything's in order and in place. That I wasn't sure, and if your question was about are people able to make this huge switch kind of willingly?
What? Am I allowed to ask Emma?
Oh, yeah,
She's a witness, right?
Yeah, identify yourself.
I've been talking to her a lot about this. I just want to clarify. If you can help me?
Yeah, I'm Emma Schultes with Vermont Dairy Producers Alliance. Thank you for the opportunity. The hope is that it's becoming increasingly hard to stay a farm in Vermont these days with added economical pressures and other things. So the ability to diversify farming, whether it be adding an apple orchard or more vegetables or going into, a stand or a camp it allows them to diversify and bring in more sources of income. And, if they're already farming, they would like the protection from their neighbors if they switch from, dairy to apple farms. We would like that protection because they'd like to stay a farm. They just need to find new ways to make income these days.
just clarification, if the apple farm changes into a dairy farm, it's gonna change a whole. You're saying it's not gonna change the rules,
As long as,
right? Because apples don't really smell, but dairy does, which is part of the problem and the runoff and all this other stuff that we're in.
as long as they're following the general RAPs and everything, yes. And, you know, there's other nuisances that could come from apple farming, like spraying pesticides late night, you know. There's different nuisances for different types of ag.
All right, thank you. Good, good? Yeah, thank you.
Yeah, the only other change, I think, to existing law, and again, this is not something that we added, it was in the draft that you were looking at, was the inclusion of for the statement that the law is to be liberally construed. And so this is something that, this is not an ag committee thing, this is a judiciary committee thing. You can better understand, I think, than we can, what that would actually mean, what the impact of that would be in the real world if we're sitting and looking at that. And I will just say that, so the committee vote on this was 7-1-0. We had a lot of discussion and I think a lot of existing concern about what Representative Goslin is, I think, thinking right now, that yes, on the one hand, it's important to recognize that the world is changing. We're trying to grow more food, and we don't want to set up barriers to farmers changing the kind of farming they're doing. But when you actually got down to it, if we were to, make these changes, what would that end up meaning? We reminded ourselves, and we heard fairly regularly that there haven't been a lot of lawsuits. Farmers are worried, for sure. They've expressed that, and I think we all hear that loud and clear. But in fact, you could argue, and it has been argued, that the law as it stands right now is working pretty well. That there have not been farms that have been sued and have had to go out of business, except for one, maybe in the last quarter century.
Thank you, Chair. Just a question on not naming the representative with the dissenting voice, but I'm just kind of curious if you could provide some context and some color as to why they were in a vote.
Sure, yeah. And although I always hate to speak for somebody else, but I think what we heard, yeah. So a concern that sort of elaborating maybe on what I just said, that we don't really know what might happen, and that what we do know is happening is currently a tendency for large farms to get larger and to take like what existing agricultural land that we have and put it into more cropland or pasture land, maybe for large operations, and that comes at the expense of small, maybe more diversified farmers who might be doing something else.
Sure. And I guess to ask a follow-up, you don't have concerns, Chair, that anything in this bill would allow the landscape to become more litigious against farmers?
If there's anything that here, I think that the intent, and I think it's probably defensible, is that it would be less contentious.
Right.
But again, there hasn't been a lot of litigation, so it would be hard to be less.
Less than nothing.
Yeah, yes. Yeah.
Or limited, yeah. Thank you.
Any other questions for David? Yeah, go ahead, Barbara.
So when we were talking about diversifying, this is not something that came up in this committee, but I know a lot of farms are adding solar panels as a way of diversifying. And I know that there are some agricultural issues with doing that as well, right? In terms of like spraying or. Does this bill also allow farmers who want to diversify by adding solar to do that as long as they're practicing by whatever the standards? I don't even know if we have standards for that, but
Yeah, so I will say we didn't hear any testimony on that, and I don't think there's anything in the bill that specifically addresses it
One way or the other.
one way or the other. Yeah.
Any questions for David?
No, not
Yeah.
a question, just, when we first got this bill, I said, why do we have it? Because I thought it might be an ag bill. And listening to you, the ag committee's understanding of agriculture is so much broader than ours.
Well,
And some of the things that you brought up and some of the, the ideas that you had and changes that you made, we never would have thought of it here. But, not 100 years, because it's not what we do. And the changes you made, I think are definitely positive changes.
I mean, I will say that right back at you, because there's so much in the statute that is, yes, it relates to agriculture, obviously, but that is really legal in a way that we're not at all used to dealing with in our committee. So like rebuttable presumption, what is that? I didn't speak to trespass at all, and I should say that we are suggesting not having any trespass in the bill at all. And that's obviously a big part of the Senate version of the bill. But we didn't understand, what does trespass mean in this context? Nobody had ever, I think, encountered that notion. So
Go ahead.
Sorry, and just one more question, just more out of curiosity than anything, but one thing that actually had a lot of bipartisan support in the committee was the mediation component of this. And I'm just curious from the practitioners on your committee, what their thoughts were on that.
yeah, I think we included that.
Yeah, I see that.
Yeah, and I think it seemed like there was no good reason from, as far as we could tell, not to include that. We did hear that, in fact, the USDA offers free mediation that would be available in this situation, so that wouldn't be a cost that anybody would have to bear. I think we also heard, that in reality, before a case goes to court, there would typically be mediation anyway. So there was some question about, well, do we need this? But we ultimately decided that leaving it in, and then I guess putting that back to Judiciary Committee, that if in fact you don't really need it, then you guys could think about that some more.
So, just to go off of what Tom was just saying, that Chair Durfee and I are going to need to have a discussion probably with the speakers to see really who should take the lead on the floor, which means, what I'm hearing, it could very well be that agriculture really should have the report of the committee, meaning that I would make a motion at some point to relieve the committee and send it to ag, so they can have an official vote, and then they would have the report of the committee, and we would just opine on some of the legal stuff. But we haven't had that discussion because it's a mix of the two things. So that will happen very, very soon. But let's talk with let's have Mike O'Grady give us walk through it, and then we can decide on next steps.
Just a clarifying question on process. So we have obviously the amended language that Judiciary, the recommended language that the Judiciary Committee sent over to House Ag. House Ag's come back with this proposal. So which is the operating version that would be voted on by agriculture? Is it the two versions assimilated together, or is it what we're
Well,
looking at?
they voted on this already with just a straw poll.
So our recommendation has been taken into consideration and no longer is part of
Yeah, I
the.
mean, that's up to us. We could say, oh, no, we like ours better. I don't feel that's.
No, and that's not what I'm advocating. And that's not what I'm
I feel we
advocating for. I just want to make sure that I understand that what's on the table is the version that is going forward.
Yes, the draft number 3.1 is
Yeah.
a matter of how it would go forward, whether it would go forward as just from us, that we'll just take their language and say it's our language, whether it's an amendment from, which seems like the least likely, because we would have to present what we have, and we haven't even voted on anything.
Right.
Or do we get this over to the jurisdiction of agriculture so that they are leading on it? Because they've done, I mean, I think that's where it should go. Personally, I think, but
I agree.
David and I have had a chance to really discuss it that much. So that's, it's a matter, it's taken a strange path, a stranger path than usual. But I think we have a path, which is the main thing.
And we, I'll just say before I get up the check, whatever you, I mean, we'll talk about it. I don't think that we're, necessarily going to insist that we get it. It's your bill, so ultimately it'll be your call. And I think we would welcome your review, I hope, in any case, just to, look at, again, some of the legal issues and anything else that you might think.
I think, if we're relieved of this, we get it one way or another. I think we're going to have some additional testimony early next week, probably Tuesday afternoon, so we can better understand this and ask more questions as well. But why don't we start with thank you. So, Mike.
Yeah.
Thank you.
You want it on the screen?
You did not.
You may be able to.
Sure. I'll make that executive
Thank
decision.
you.
Vice Chair spoke.
No.
Hey, can you actually send me an invite? I'm using a borrowed iPad today, so.
Your email.
Yep. Or actually through Zoom, if you can do it through Zoom. Great, thank you. Yeah. Thank you. Can you mute me? I cannot get it.
There. That should be it.
Does it work? Can you try to put your fingers? Okay.
All right.
It's still having the reverb issue.
Well, should we just go off our?
Nah, just leave you off.
Yeah.
Yeah, let's do that.
All right, so. What has changed? So the first thing I'd like to point out in reference to some questions that were made earlier is in the legislative findings and purpose law, which is that You should know that what makes that protection difficult is something I will address in 1 minute. Then you'll see the definition of generally accepted agricultural practices. It is unchanged from what you were looking at. It is still, you need to comply with our RAPs. So to comply with the CAFO permit, you have to comply with the pesticide rules, and you still have this kind of catch-all at the end: practices conducted in a manner consistent with proper and accepted customs and standards followed by similar operators of ag activities in the state. And that is there because the pesticide rules, the CAFO permit, the RAPs, they don't address all aspects of farming. They don't address things like noise or odor or vectors or pests that could create a nuisance. And so that catch-all is there to both allow for the farmer to say, we're complying with all accepted practices and therefore we shouldn't be a nuisance. But it's also there to basically allow a plaintiff to say that that type of activity is a nuisance. The good standing with the state has not changed. It's still, if there's been an enforcement order that's reached a final order with A&R or the agency of ag, they did remove your definition of nuisance. They did remove your definition of the 25-year, 24-hour flood event or the annual exceedance protection. They didn't want to change the standard of nuisance. They just wanted it to rely on the common law. And they removed trespass and they removed water and the ability to bring, or the removal of nuisance protection for water.
So with something like, say, odor, which would be something that you could possibly bring a suit, would it be, David had talked about another piece of the bill where it would be up to the plaintiff to prove that practices weren't being followed. Would it be the same with those that the plaintiff would have to prove?
Yes, yes. And for odor, generally odor is from the use of manure, and the plaintiff would have to show that what the farmer is doing, their application, their storage, their land stacking, etc., is not consistent with the customs and practices in the state. And that will be on the plaintiff to show. On page 4, you're now in the actual protection from nuisance lawsuits. You're moving away from the rebuttable presumption. You no longer have the farmer with the burden of showing that they're acting consistent with good agricultural practices, that they were established prior to surrounding non-ag activities, and they have not significantly changed since commencement of the prior surrounding non-ag activity. You just have that statement, page 4, line 16 through 18. No agricultural activity shall be or become a nuisance when the activity is conducted in accordance with generally accepted agricultural practices, which is what we just walked through the definition of that. And in order to assert the nuisance protection, the person conducting ag activities has to demonstrate they're in good standing. Same language you have, the letter from either secretary or both, if relevant. Page 5, line 6 through 14, the plaintiff is the one that shall have the burden of proving by a preponderance of the evidence that the activity is not entitled to nuisance protection because it is not conducted in accordance with generally accepted ag practices. And if the plaintiff proves the ag activity is not entitled to nuisance protection, the plaintiff still needs to show the required elements of the nuisance claim. The nuisance protection does not apply when the violation results from negligent operation. And then you had that if there's a substantial adverse effect on health or safety, and they changed it to health, safety, or welfare, which is the current language. And they also added that it does not apply if the ag activity has a not just insignificant interference with the use and enjoyment of the neighboring property. Now, those two provisions might seem familiar to you because they are the current ways to rebut the presumption that a farming and ag activity is not a nuisance. So you retain that ability of the plaintiff to continue with the nuisance claim. A, if the activity was from negligence, but B, if there's a substantial adverse effect on health, safety, or welfare, or the activity has a noxious and significant interference with the use and enjoyment of the neighboring property. So the neighbor, the plaintiff, still has opportunity to bring a claim and prevail.
Seems like a heightened standard though. Well,
I mean, you've definitely relaxed what the farmer needs to show about being there prior, about conforming with state, federal, and local law, et cetera. But you're also still allowing the plaintiff to have a remedy if they can show one of these things.
What did you mean, like, when you said being there prior?
So currently, current law, you can see this on page 4, I think. Yep, page 4, line 9 through 10. Current law, in order to qualify for the presumption that you are not a nuisance, the farmer has to show that it was established prior to surrounding non-agricultural activity. And you move that. So remember, purpose of this law, farming is going to expand, farming is going to diversify, farming is going to move onto parcels where farming didn't occur before. You want to provide that type of activity with some protection, provided that they're not negligently operating, provided that they're complying with the good agricultural practices, they're not creating substantial effects on public health, welfare, safety, and they're not significantly creating adverse effects, significant interference with the use and enjoyment of the neighboring property. So it's easier for the farmer to assert the nuisance protection. Plaintiff neighbor still has opportunity to overcome that.
You should. Oh, yeah, Angel.
Mike, maybe this might be very obvious, but on page 5, line 13 and 14, where it says the plaintiff must show, provide the required elements of their nuisance. Are these required elements?
So that is something that changed from your version to the ag version. You defined what nuisance was, and so it was very clear for purposes of this protection what the plaintiff had to show. There was testimony that from advocates that definition effectively changed what the common law standard is for nuisance. And the advocates asked that the definition be removed and just to allow the courts to apply common law. Right. So
nuisance claim.
Right. You just have to show that you meet the standard for a nuisance under the common law standard.
Okay.
And that's once you've defeated the nuisance protection. Right. That's once you've shown that the farmer doesn't qualify for the nuisance protection. You still have the burden to show that your nuisance claim is valid and should be subject to a remedy.
Do you happen to know off the top of your head?
It's you have to show that
Or if you know the site, I can look it up too.
it's not defined in statute. It's in you know what, so that I don't misstate the standard, which a couple of law professors have called me out on this term. I will send you the exact standard so that I won't get a gain.
Yeah, you know what? Yeah.
I may have missed this. Is there a definition for what noxious is?
No, there isn't, and that would be fact dependent, kind of up to the court.
So I guess reading it now, and my question is, am I seeing this right? it sort of seems like we're kind of moving the battle to subsection 3 of the sort of caveats for the nuisance protection not to be in effect. So like every plaintiff is going to argue that the nuisance protection is not applicable because the nuisance is creating significant interference. So there's going to be like, that's going to be where the battle happens.
Remember that those two standards are existing ways to overcome the rebuttable presumption.
Yeah.
Right now. So they are already partly where the battle occurs. But you're correct. It is now shifting. It's no longer overcoming a presumption. It's you defeat that nuisance protection. And maybe they're 6 of one, half dozen of the other.
Yeah.
But it's now easier for the farmer to assert the nuisance protection, but you're not taking away that remedy. And it will be a fact dependent battle, like what is noxious? Is the compliance with the generally accepted customs and practices of the area for that in the state noxious?
Because that's, I guess you could.
Noxious, but then significant interference with
Yeah.
use and enjoyment. And so this law, as it currently is drafted and as it would be drafted after, it's not going to prevent litigation. It just shifts the litigation to proving that the nuisance protection doesn't apply based on the facts of each situation.
Yeah. Oh, thank you very much.
Following that, though, it does seem, am I correct in understanding that I highlighted noxious and significant interference as well, like, that seems rather subjective. But you can only get to that if you can prove that the agricultural activity is not conducted in accordance with generally accepted agriculture practices. Correct?
Well, now it's 3. You can get to it.
It's
Right. You can say the plaintiff could argue that they don't deserve nuisance protection because it wasn't conducted in according to gen, or they can't prove it and the farm is being conducted according to generally accepted customs and practices, but it's creating a significant noxious, significant interference with their use and enjoyment of the property.
Okay. Yeah, that's.
It is not as strong as what other states do. But they wouldn't allow, or many of them would not allow that type of standard. But some do. Some do, in order to allow that plaintiff neighbor to have a remedy. And that's, I think, what the balance. There was definitely a discussion in the Ag Committee about balancing how much protection a farm should have.
So they looked at this closely and they debated that language.
They definitely took testimony that the plaintiff, the neighbor, should have a remedy. And they still have a remedy.
I'm just gonna be testifying, so.
Okay, all right, okay. We'll move on.
Okay, I don't know what that means, but
That I'm controlling myself.
okay.
I didn't have a question. In a
Um,
good way.
One of the things that your committee was discussing was not allowing the nuisance protection for harm caused by flooding, etc. And that was removed. There was just too many questions about that, how it's going to apply. And they removed that entirely. And one of the other things in the liberal construction, so liberal construction, it's about instructions to a judge or a jury that's looking at the application of the law. Like, there's strict construction where you look at specifically the meaning of every little word and how it applies and to the facts. And there's liberal construction where you're construing the general law to effectuate the purpose of the law. And so there is less scrutiny of the specific words and application. That's what you're trying to say here. This chapter should be liberally construed to provide that nuisance protection that you looked at the beginning of the walkthrough for those farms that are diversifying and changing and having to grow. That's what liberal construction and a directive for liberal construction. It's usually provided for remedial statutes where you're providing, some sort of remedy. And here you're providing effectively the remedy for a farmer, protection for a farmer, but that's why it's here. One of the things that was removed, that there was previous language where a farm would not lose its protection if it had been there for 5 years or gone fallow for 5 years and then restarted. And the committee upstairs decided it just wasn't necessary. It was kind of superfluous to the standard that you needed to show anyway for nuisance protection, and they removed it. And then the required mediation prior to suit has not changed, except for the removal of the word trespass.
Any other questions for Mike? All right, I appreciate that. So before we go, because this afternoon, the question is whether we need to take more testimony or defer to where agriculture is. And I think I talked to Tom, and I think that's what we want to do is to defer what this is. We've taken plenty of testimony on this, and ag is, I think it's mostly in their jurisdiction and their value. So that would be my intent, but I'm gonna still talk to other folks to see if we're gonna relieve ourselves so they can be the main people on the floor or how we're gonna approach that. And if in fact we are going to be still in possession and have the report, then we probably will take some more testimony just to make sure, but I'd rather avoid that. So we're good. Thank you, Mike. And before we leave, because I'm not sure if I'm going to have Alicia or other people I'm going to lose this afternoon, so we don't have to meet after the 4. I do suggest that people who are going to be working or part of the report of S109, that they probably can meet this afternoon. Yeah, thanks, Mike. They can meet this afternoon after the 4 to kind of get ready for the report. But before we break, I would like to take a motion to find version. This is the 109 amendment.
3.1. Is it 3.1?
Yeah, version 3.1 of S109. Yeah, that we find that favorable amendment. And a second. All right, we have that again. Are we ready to vote on that? And we don't have, it's just a straw poll. All those in favor of the amendment, raise your hand. Coach, you good? Yeah. Okay, Alicia, you good?
Yep.
Okay. All right. I will get Zach's vote later. Right now it's 10-0.
So shall I let Betsy know that, or shall I? Wait?
Yeah, you can. No, you don't need to. No, we don't need to stop it. On the amendment, we don't.
Right.
Do
Okay.
That. But what
Just
you want to do
is
send the amendment to Nigel that this is an amendment. Oh, wait, do they put that?
Yeah, I think they do, but she wanted the link.
Is she recording this thing tomorrow?
Yes, it's on second reading tomorrow.
But we already have the walkthrough too, so all you need is your part.
Okay. So yeah, so people can meet after to kind of just get your part and all that.
You're going to your science parts.
Yes, I'm working on assigning you parts and I'm putting
All right,
in
and we'll
the.
adjourn